Good morning. Welcome once again to our live Q&A on child custody and child maintenance. We never had one of these for some time. We had a few webinars for the last few weeks, and that took up a lot of time, the organizing thereof. And of course, there's a lot of admin involved where that is concerned. But nonetheless, we are back with our live Q&A on child custody and child maintenance, where you may pose questions live via Facebook Live. So if you're watching this video on a platform other than the Advocate Mohammed Abduroaf Facebook page, please head over to that page. In the description to this video, you should find the link. And when you're on that link, you're welcome to pose a question in the comment section. I'll be viewing those comments and I'll be answering those specific questions. As I mentioned, child custody and child maintenance, anything relating to that. Generally, that deals with everything: guardianship rights, application for an increase in maintenance, application for a reduction in maintenance, non-compliance with maintenance orders, parents refusing a contact to a minor child, wanting to have more contact, wanting the other parent to have less contact, parenting plans, relocation issues, and so on. So that's what our Q&A will deal with today. Please put in the comments where you're from. If you do not wish to ask a question, say hi. Are you from Cape Town, Johannesburg, KwaZulu-Natal, wherever you're from? It's always good to know who's watching these videos and these webinars. But at the same time, you are welcome to pose whatever questions you may have. Many people, they have specific legal problems and they go online and they try to find the specific answers, and they cannot find those specific answers because, number one, they are not lawyers, and sometimes the person that wrote those specific articles dealt with a specific scenario, and it does not necessarily relate to your specific scenario or your specific problem. Therefore, I am hosting these videos in order to give you, the public, an opportunity to engage with a family law expert, someone who, in my view, I've done all possible family law issue scenarios. I've represented the father, the mother, the grandmother, the aunt, the uncle, the sister, the brother. I've done it all. And hopefully I would be able to assist you in answering whatever questions you may have. Okay, wonderful. We have somebody from Cape Town. And we have another comment. Thanks for doing this. You are welcome. And I hope I have a question from you as well. Generally, if no questions come, I start speaking and I start explaining the law, and those specific questions do come later. However, it's always good to get into it immediately because these webinars are about half an hour to 40 minutes long. And if the questions do come later on, I cannot do much justice to your question. I'll have to answer it quite quick because I have to attend to some other things. But nonetheless, please feel free to pose your question and I will assist you. So what do we have to know? Firstly, on child maintenance, we are still in the lockdown. We are still, there are still certain restrictions at play. People are not allowed to be out at certain times. Schools are still, working one day on, one day off. School fees must still be paid. So things are a bit different, and that obviously affects a lot of things: the budget, the economy, paying off maintenance. As I've mentioned almost a year ago now, when this whole lockdown started, there is no payment holiday during the lockdown. You still have a legal obligation to maintain your child. The law didn't say change, stipulating that, seeing that it is lockdown, your obligation to maintain your child falls away. The law never changed at all. The law is still the same. However, if you cannot afford to pay the full amount of child maintenance which your child requires, our advice is please speak to the other parent and come to some type of an arrangement, some type of an agreement. If you cannot come to that agreement or arrangement, then one of the parties must go to court. If you're the one who is supposed to pay child maintenance, you should approach a court and ask a court to change the maintenance order if there is a court order in place. based either upon a divorce or a maintenance application in the maintenance court. If there is an agreement between the parents that you should pay X amount of money and you have always been paying that amount of money, but now due to COVID-19 and the lockdown, you can no longer afford to pay that specific amount, and you cannot come to an agreement regarding a different amount, a lesser amount. And then under those circumstances, if the other parent is not willing to agree to that, then that other parent needs to approach a maintenance court, and the maintenance court will have to resolve the specific issue as soon as possible. Remember, and this is quite, elementary, but some people do not know this, maintenance get used to feed a child and clothe a child and give a child shelter. There are other things that the maintenance gets used for as well. Education, extramural, medical, and so on. Therefore, if you are paying child maintenance, that is what the money gets used for. I cannot understand a parent will live a life whereby he will have food on his table, he or she will have clothing on his or her back, but they are okay with their children not being fed and not having food on the table. That causes a bit of problems for me. They are happy to have a nice cell phone, an expensive cell phone worth a few £1,000, but at the same time, they're not willing to pay child maintenance, or they want to pay no child maintenance or very low amount of money towards a child, which actually gets used for food, clothing, etc. If the maintenance does not get used for that, then obviously there's an issue involved here. But what I'm seeing a lot, people are making that comments. A child needs to eat, a child needs clothes, a child needs education. But the other party believes that the mother uses all that money for herself. But then my question is, how does the child survive? Obviously, if the father pays, for example, £1,000 per month towards the mother, and the mother uses that specific money for her own self, but she feeds the child, she uses a different aspect of her money, a card, she swipes it for the child, clothing, food, education, and so on. So he's still contributing. Had he not paid that money, the mother most probably would not have used, the money to pay for those specific expenditure. So it's very important to note that food and clothing is child maintenance, and if you do not pay your child maintenance, you are doing yourself and the minor child a big disservice. I see some questions coming in. Wonderful. I shall deal with it in a moment. Just to conclude on the issue concerning child maintenance, if someone says he cannot afford to pay child maintenance, it does not mean that he should not pay child maintenance, because his concept of affordability might not be correct in law. For example, if you have an expensive cell phone, you should sell that cell phone, buy a cheaper cell phone that has WhatsApp and SMS, and use that money for child maintenance. If you have a car and you lost your job, you need to sell that car, buy a cheaper car, and pay your child maintenance. If you have property, if you have assets, you need to liquidate those specific assets to pay your child maintenance. So a parent who has a lot of assets, whatever it is, cannot say, I have no income. That is wealth. You need to sell it. You need to downscale in order for your child to have food and clothing to wear. So I think we understand that specific topic, and we can touch upon it a bit later on. Okay, I have the first question, and I won't put it on a whiteboard today. I will just read it from the screen. If there is a Rule 43 from the High Court in place, and I need to reduce the maintenance amount, can it be done in the Magistrates Court, or must it be done in the High Court, as the Magistrates Court say I need to approach the High Court? So a Rule 43 application, let us first deal with the foundation of a Rule 43 application. In the High Court, there is a rule that says if there is a pending matrimonial property dispute, either someone issued summons for a divorce, I'm using a simple example here, or someone intends issuing a summons for a divorce, but generally the person would have issued a summons for the divorce already. So there are kids involved. The husband took the wife to the court, to the High Court, saying he'd like to divorce his wife, and there are certain minor children involved. Fine, so there's a pending dispute in the High Court, case number, etc. Now there are problems regarding contact or care or child maintenance issues. One of the parents may approach the High Court in terms of Rule 43, which says that you can approach the High Court pending this matrimonial property dispute, this matrimonial dispute or this matrimonial issue, and the court can make an interim order. Therefore, you may approach the High Court for an interim maintenance order and also for care and contact and so on. The High Court will peruse the applicant's documentation, and then the other party, should it be the husband or the wife, will file their documentation explaining why the order should not be granted, etc. So, for example, the mother will go to the High Court and stipulate, in a Rule 43 application, the minor children cost so much money, I earn so much, the father earns so much, I need so much, the father's not paying so much. The father will come and he will file some documentation and he will stipulate, no, I cannot afford what the mother is requesting. I think a reasonable amount of money to pay will be so much, etc. Those two pieces of documentation gets argued upon and the court will make a decision. So the court will make a Rule 43 order, or an order in terms of Rule 43, which is a maintenance order, they call it pendite late, pending the finalization of the specific litigation. Now that specific order stands until the divorce is finalized. Therefore, if you have a problem with that specific Rule 43 order, you need to approach the High Court again in terms of Rule 43.6 and prove to the court that there is a material change in circumstances. One of that could be, for example, that you've lost your job, or the other parent automatically obtained a higher amount of income, or, for example, the minor children no longer cost so much money. So that's material. Because why must you pay the mother 10,000 rand per month if the children are no longer requiring that 10,000 rand per month? Whatever the facts are. So the specific questioner, the commenter now asks the question, can they go to the magistrate's court? No, you cannot, because the matter is pending in the High Court. And the High Court made that order. You need to finalize the issue in the High Court, because the High Court has all the documentation, has the whatever pleadings were presented, whatever arguments were presented, it is in the High Court. If you approach a magistrate's court, I can't see the logical basis for doing so. Are you challenging the High Court order? Has there been a material change in circumstances, whatever the case may be? So my advice to you is approach your attorney, whoever it was. If there has been a material change in circumstances, make an application in terms of Rule 43.6 for a change of the maintenance order. The magistrate's court can't assist you in this specific regard. The only time the magistrate's court can assist you is if the divorce gets finalized and now there's a change in circumstances, and then you can approach the magistrate's court for a variation of that order. Okay, I hope that answered that question. If I have not answered the question correctly, please leave additional comment and I can add on to that. The second question is, I am going to the maintenance court tomorrow. Will they be able to assist me with a Rule 58? Okay, I'm unemployed and battling to keep things afloat, and my children's father has stopped all benefits. Our divorce is not even close to finalized yet. Let me go further down here. I have sold whatever personal belongings I was able to, and the father is hiding financial information from the courts. Please help. So a Rule 58 application, very interesting webinar today, whereby we're having the first two questions. One deals with a High Court application for interim maintenance, and the second question deals with a Magistrate's Court rule dealing with interim maintenance. So a Rule 58 application in the Magistrate's Court deals with the same what I spoke about in the High Court. You would not approach the maintenance court for a Rule 458 into the maintenance order. You will approach the divorce court for that. You will approach the maintenance court for a maintenance order. So I hope that assists you over there. So even if the High Court, even if the divorce hasn't been finalized, it's far from finalization, etc., you can still approach the divorce court for an interim maintenance order. The question someone will pose to me, is it better to approach the divorce court for interim maintenance, or is it better to approach the maintenance court for interim maintenance or for maintenance order? My advice is it's better to approach the divorce court, because they deal with the matter very robustly and very quickly, as opposed to approaching the maintenance court. The maintenance court will have to do a full-blown inquiry, which can take many months to be finalized. They'll have to locate the other party, they'll have to subpoena him to the maintenance court, which could be a bit exhausting, and it could take extremely long to be finalized. What if they cannot find the other party? But the mere fact that you are in the divorce court already, the parties' addresses are on the specific legal documentation, and you can just expedite it. So I know in the High Court for Rule 43 application, it can be finalized quite quickly. When I say quickly, it was probably in 3 months maximum. Okay, we are busy with COVID-19 at this present moment, so I do not know how the court's diaries are. I know they're taking a bit longer to give us dates, but I'm certain there will be you'll have the same problems in the maintenance court as well. Sorry about this. I'm just trying to share this webinar. Somebody wants me to share it on a different platform. And nonetheless, that's sorted out. Okay, so I hope that answers your specific question. So go to the divorce court and have the divorce court assist you in obtaining some type of maintenance relief, because the matter is pending at that specific court. If there are any additional questions, please feel free to pose it. I will start speaking about child custody a bit, and I'll be waiting for any additional questions to come in. I think we are live now for 17 minutes. Okay, we're almost halfway, or close to halfway. I see an additional question, which I maybe can deal with immediately. The comment is, will we ever get rid of corrupt syndicates in the children's courts? The SACSSP and Law Council not helping. I cannot answer that question. I mean, I hope they get rid of all corrupt officials in all the courts in South Africa, not only the children's courts. That's not fall under my domain. I'm a private practitioner, so I can't answer that question. The government, politicians, they should be able to answer that question and take responsibility for their departments. The Constitution clearly places an obligation upon government to do their job. And if they do not do their job, people suffer. And I've experienced it many times where officers and court officials, I wouldn't necessarily say from my side corrupt, because I know I'm a legal practitioner, I don't act corrupt, but I can see the possibility of corruption being perpetrated if the circumstances allow for it. But my advice to you is, speak to the politicians, speak to the provincial minister of justice, complain to him or her. I do not know who the new minister is. Speak to the minister of justice, the head of public prosecutions in South Africa, and so on, because maintenance officers falls under them. I do not know who children's courts officers fall under, but they should be under the Department of Justice, and lay complaints by them. I hope that assists you, and I hope corruption does come to an end as soon as possible. I have an additional question. Let me deal with that. My son's dad is not working, so he doesn't pay maintenance at all. He was named one of 3 executors on his late father's estate. Him, his brother, and mother. The mother sold the property to the brother. They have not paid him out. He signed legal documents drawn up by his mother and brother and doesn't know what he signed. What are my legal rights to claim maintenance from them for my son, please? Okay, so I do not understand the question so well, in the sense of your son's father is not working. His father passed away, and there was some type of a estate issue there, and the party signed some legal documentation. The question is, what are your legal rights for your son? So your son cannot claim from the estate of the grandfather. It doesn't make sense for him to do that. Maybe technically or theoretically possible, it could be that the estate could be held liable, but I cannot see anything happening there. The father should do research. I mean, if he signed documentation, he must know what he signed. He needs to, if he inherited certain type of monies, he needs to claim that specific monies. Because if I do not know what he inherited, and all that I'm seeing that he is an executor of the estate, as the case may be. So my guess is just as good as your guess. I think what you need to do is find out exactly what the will said. Very important. Does the father inherit? If the father does inherit, there should be some type of financial benefit to him, and at the same time, if he is signing any portion of his inheritance to another party, there should be additional financial benefit to him as well. And then that specific financial benefit should sift down to your son. I hope that answers your question. I'm trying to make logical sense of your scenario. If it doesn't, please leave a further comment. Okay, the comment regarding the corruption, he says, thank you, you are welcome. An additional question, can one get child maintenance when the baby's daddy said you must abort, but decided to keep the baby? I get that query a lot where people tell me or advise me that the parties were involved in a relationship and she fell pregnant and the father wants the child to be aborted. It's not something strange to my office. I hear it a lot, but obviously the child was not aborted. That's why they're before me. If no child was born, then there will be nothing to discuss. And years go on and that issue keeps on, resurfacing. And the question is, does that issue or that comment made by the father affect his parental rights, etc.? My view, no, because the child was born. That was a discussion the parties had. Regarding the specific questioner, if the parties agreed to have the child aborted and they did not proceed with abortion, can the mother still claim maintenance from the father? Yes, she can. Abortion or whatever happened before the child was born, whatever discussions or agreements, it is irrelevant at this present time. I'll even take it a bit further. If a mother falls pregnant and she and the father comes to an agreement that the father should not pay any maintenance to her and she will not claim any maintenance from him, they even have it in writing, stamped by the police officer, commissioned, that piece of documentation is worthless because you have a legal obligation to maintain a child which supersedes any agreement which you had with another party. So that is fine. So I think no court of law will enforce such an agreement. So regarding your specific question, can you claim from the father, although you most probably said I will abort, or you guys both agreed to abort but you did not have abort, you still may approach the maintenance court and claim maintenance from the father. You're welcome to do that, and your case will be dealt with as any other maintenance court case, and the issue concerning the abortion is irrelevant. The court won't even listen to that. Okay, the questioner of earlier says, thank you for your response, but it's complicated. You are welcome. The issue concerning the will and the trustees. I hope I answered your question regarding the claim of maintenance against someone, the father of the child, whereby you guys agreed to abort the child, but you have not aborted the child. Thank you for the questions. I think we are doing quite well today. We had about 6 questions that came in today. If you have any additional questions, feel free to pose it. I'll be happy to answer it. Please remember to go to the Advocate Mohammed Abduroaf Facebook page. Getting a bit thirsty today. And on that specific page, you can pose the questions. Please like the page or follow the page, and you'll be notified of future questions. If you do have any questions in the future and you're watching this video later, other than the live one, please copy and paste a question somewhere, click on our alerts, so the next time I go online you'll get an alert on Facebook, and just copy and paste a question and we can take it from there. Usually we have a whiteboard, which I'm not dealing with today, and in the future we will allow people to call in via Zoom as well, so you can interact with me verbally, which helps a lot. Our webinar did incorporate that, our last 2 webinars, and it was very successful. People could engage with me and I could understand the questions, because if you type out the question, I might not understand it because you have all this knowledge in your brain and you presume I will understand it. If you verbalize the question, I can hold you there and ask you an additional question to clarify certain things, and we can get to the bottom of whatever needs to be resolved. Another question, wonderful. My husband doesn't want to sign my parenting plan. Okay, that's what the person say. Please help. Now, a parenting plan is an agreement between mother and a father dealing with the parental rights. For example, care, visitation, contact, guardianship rights, maintenance, etc. How are you to parent, co-parent a specific child? That's basically a plan. So, depending upon the age of the child, the plan will be different. A 16-year-old child parenting plan will be different than a 15-year-old or for a 10-year-old child or for a 2-year-old child. So, all parenting plans will generally be different, and each family and each household is different. One family, the father works from 9 to 5. Another family, the father works from 9 to 2. One family, the father doesn't work. The other family, the mother works, etc. And on one family, the children are good at academics. They live close to the school, and another family live far from the school. So those are all the family dynamics. So a parenting plan, it should be hard to find a parenting plan that fits two families. It's possible, generally, if it's, kids almost probably 17 years old, they all got the same type of requirements, then it's possible, but generally, parenting plan should be customized to your specific family and child needs. I do not believe in making use of templates. Templates are good as a starting off point, but you need to unpack it and make sure it works for you. So if the template you first receive says contact for the father will be from a Friday after school until a Sunday at 5 p.m., will that work? Will it work? After school, what time is after school? Aren't the parents working? Isn't the father working that specific time? Wouldn't it be better to stipulate maybe the Saturday morning or maybe the 5 o'clock of the Friday? And why Sunday after school? Well, why Sunday 5:30? Would it be more applicable or approachable or more practical for contact to take place until the Sunday 1 o'clock? Because then the father can take the kids now with him to lunch and then give the child back to the mom. I'm just being difficult here, but where I'm trying to go to is that parenting plans needs to be workable for your specific family and your specific scenario. I do not believe in template parenting plans. I got most probably 1,000 parenting plans on my computer. What I do is I consult with my clients. I look, okay, you are more or less that type of specific parenting plan you require because the kids are school going age, both parents are working, etc. I'll pull that from my PC, but then I'll still have to customize it to be workable for you, so there will not be problems in the future. So in this specific case, the parties cannot agree upon a parenting plan. The father doesn't want to sign it. He has full right not to sign it. It's not a parenting plan if it's not agreed upon. So for argument's sake, let us say the mother presents a parenting plan to the father. The parenting plan specifically stipulates that the father will only see the children for every second weekend from the Saturday until the Sunday, and that's it. Telephonic contact maybe once a week, etc. The father's not happy with that because he exercised contact much more than that in the past. The kids used to stay by him from the Friday till the Monday, etc. Why must he sign the parenting plan? Because the mother just presented it to him. And at the same time, let's say the father drafts a parenting plan where he says he wants to have custody or he wants the kids to live with him during the week and the kids should visit the mother on the weekend. Will the mother sign the parenting plan? The mother won't sign the parenting plan. The same way with the father. So the parties can't come to an agreement. So my advice to you, to the commenter, thank you for the question, would be both of you must see a professional, a mediator, a family counselor who can assist you in unpacking the terms of the parenting plan. Maybe approach a children's court, and the children's court might be able to assist you. And hopefully you guys can come to an amicable agreement regarding the terms of the parenting plan. If you cannot, you can't force anyone to sign it, the court will make an order. Then it will no longer be a parenting plan, it will be an order of the court. I hope that answers your question. If it did not, please feel free to comment further. The next question I have, is there any legal rights for grandparents? Okay, the question, maybe to rephrase it, does grandparents have any parental rights to their grandchildren? Now, the quick answer would be no. Mom and dad, they are the responsible parents for the minor children. They made the child and they should parent the child. You should not burden mom, grandma and granddad, the opa and the oma, with looking after these kids. It's the mom and the dad, and the mom and dad can decide this weekend we're going to visit grandma and grandpa, but next week we're not going to visit because we've got other plans. We're visiting a different set of grandparents. The parents, this is their kids, and they live their own lives. And obviously, we expect the parents to take the grandchildren to the grandparents. But they live their own lives. If they want to decide to live now, to go to America, to the United Kingdom, to Australia, to live in a different province, that's it. Right? They don't have to check, okay, grandma, grandpa, is it fine if we go because you guys have parental rights? No, they do not have parental rights. So that's the quick answer. However, because our law follows a child-centered approach, not a parent-centered approach, a child-centered approach. In other words, we look at what's best for the child and not what is best for the parents. And the third parties as well. If the grandparents were well involved in the minor children's lives, they are part and parcel of the grandchildren. They see them every day. They have contact all the time. Things are going great. And now the parents are now saying, no, you cannot have any contact with the grandparents any longer, whatever the case may be. Or the parents are neglecting the kids, whatever the case may be. Then under those circumstances, you can approach the court and you can acquire parental rights over the grandchild if it is in the child's best interest. Yes. So the question is it in the child's best interest to have grandmom, granddad always having a control over the parents and the grandchild? No, it's not in the child's best interest for that. Parents need to live their own lives. If they only see the grandparents once a year, that's unfortunate. But parents need to live their own lives. Is it in the grandchild's best interest for grandma and granddad to always be contacted and be informed about decisions? No, it's not in the grandchild's best interest regarding that. But there is a scenario if the grandparents were well involved in the minor child's life and they feel that it will be best for them to continue being involved in the grandchild's life. Some grandparents will be fine. No, you guys continue with your lives. Do whatever you want to do. You are the parents. You take responsibility. But if that first scenario applies, where the grandparents want to be involved, they need to approach the court, and the court can assign parental rights to the grandparents. So it is possible. I've made these up applications for grandparents, for aunts, etc. The court will have to determine what is best for the child. For example, one scenario which I dealt with in the past, quite recently, whereby the grandchild was cared for every day by the grandparents and the maternal aunt, yes. And the mother was on a deathbed, living with the maternal aunt and the maternal grandparents, and they cared for the grandchild. And then the mother passed away, unfortunately, and then the maternal family continued caring for the grandchild. Now the father wanted to have final say and say, no, I do not want you guys to be much involved in the child's life, etc., which he has the right to do. He has to be the parent of the child, but the evidence clearly shows that he is unable to care for the grandchild as well as the grandmother and the maternal aunt could. And the matter went to court. We settled the matter, but ultimately, under those specific circumstances scenario, it made sense for the maternal grandparents and the maternal aunt to still actively form part of the grandchild's life. And the court made an order of court. So the court gave the grandmother and the maternal aunt parental rights. So it is possible to acquire it. So I think the question goes further to see the grandparents. I think I answered the question. You don't have an initial right, but you can acquire those rights. You can't go, for example, to the police station and say, hey, Mr. Police Officer, my child does not want to allow me as a grandmother to have contact with my child. They'll say, there's nothing we can do. You have no right. Okay, the questions are coming in nicely. What can I do? Father of my child is not helping with my maintenance. He claims he is not working, but he recently brought our child a phone worth 5,000 rand. I have a maintenance order which he chooses to ignore. The long and the short of it, you got a maintenance order. You need to enforce that order. you need to go to the maintenance court as soon as possible and lay a complaint at the maintenance court for non-compliance with the order. One of two things: they will either attach his property, or they will have him called to court, and he could possibly get 3 years jail time for that. So that's a quick answer to you. Go to the maintenance court and lay a complaint ASAP. That should have answered that specific question. If I had not, you are always welcome to comment further. Okay. I have a second last question, and I will deal with that. And I see we're now online for 35 minutes. So unless more questions comes in, we might have to cut it short after those two questions. I like Friday afternoon at school until Monday morning at school, if you can, less provoking. Yeah, so I do not understand where that is coming from. Let me see the question above. Okay, I think there's a comment over here. So the comment is basically saying that he prefers contact to be implemented from Friday after school until Monday morning at school, which is less provoking. So the whole logic behind that is that you collect the child from after school, you do not have too much contact with the other parent. Simple as that. The agreement is Friday comes, collect the child from school, the child should have all his homework and things he requires for the weekend, if there is school the Monday, if there's homework assignments, and then all that he does is he drop the child back at school the Monday morning. After school, the parent collects the minor child. I see additional comments, says weekend contact, yes. So I like that idea. If it's workable, wonderful, great. That's why I'm saying a parenting plan. If the parties can come to that agreement, if the agreement is that the father should see the child only once a year, that's the agreement. And once a year he comes, he pitches up, he has contact with the child. Wonderful. I'm happy because everybody else is happy. It's not my family, it's your family, and it works for you. But if the plan does not work, it causes more problems, we need to look into that. I have additional question. Thank you for that. Okay. How can a child be able to make decisions in living with either one of his parents? I think the child must be 18 years old. He needs to be an adult. He cannot make a decision. A child is a child. We can listen to what he has to say. We can weigh and consider what he has to say, but he doesn't make the decisions at all, or she doesn't make the decision at all. Because what, for example, let's say life at dad is great. McDonald's, Kentucky, what else do people eat nowadays? The youngsters eat Spur. You know, on the weekends, from after school, dad picks him up. We go to the beach, we go to the pools, we go to soccer, we go to rugby, whatever the case may be. Life is great at dad's house. Cousins comes over, friends comes over, etc. Monday comes, Sunday night comes. Child said, no, I want to stay with dad because life is great. Dad doesn't do homework. Dad makes the child sleep whenever he wants to sleep, eat whatever he wants to eat, do whatever he wants to do, etc. I'm using very extreme examples here. And that's a logic behind why the child wants to live with dad. Now the child makes a decision, I want to live with dad. Dad can't do homework. So, but mom on the other hand, she's great, you know, she attends her homework, but she's strict, you know, she scolds the child out a lot if he's naughty, if he doesn't do his homework on time, doesn't do his chores, doesn't wash on time, whatever the family situation is. If he speaks badly, mom does that. Mom teaches the child life things. There's nothing wrong with dad. Dad is an amazing guy. But dad is fun. And with mom, it's hard work. And that's what the child is picking up. And also when we go on outings on a weekend with dad is fun. But mom's weekend is boring. You know, mom never has money. Mom has an old car. Mom has old friends, decent friends. They're all boring. Dad's friends are more exciting and adventurous. So therefore, me, 16-year-old child, I want to live with dad because life is great. We listen to the child, you know. All that we can say from that scenario, in my view, and I'm not a psychologist, but all that I can say from that scenario is that the child is comfortable being with dad. Therefore, dad should have his specific every second weekend, unsupervised, etc., because the child is comfortable with him, and there's nothing wrong with dad at all. But there's no social welfare issues. Dad is fine. That's just a cool dad. But regarding whether or not the minor child should now be primarily cared by dad, That doesn't make sense to me. The mother should continue being the primary caregiver. So regarding the age, we can listen to what you have to say, but we cannot give you the final say. Once a child turns 18 years old, he's an adult, he can live with dad. I also suggest that he lives with mom because mom's a better mom in our fictitious scenario. Okay, our last question. My ex-husband got full custody of one child in 2017 and the child stayed with him from 2018 until 2019 September because he beat him up and the child didn't want to stay with him. So my ex-husband refused to pay. Okay, some question came in here. So my ex-husband refuses to pay for his transportation to school and he doesn't want to give him lunch money. He says that's not his responsibility anymore. Must I go back to the children's court or maintenance court because now I am maintaining 2 kids? You need to go back to the maintenance court. And if the maintenance order specifically dealt with the situation regarding him paying for those expenditures, then it is in violation of the court order and criminal charges can be laid. If it's not clear on that, if the maintenance order says that he should pay X amount of money, but he paid X amount of money in terms of the court order because the court order said pay that and that's it. And at the same time, he also gave this additional money which you are referring to. Now stop doing that. You need to approach a maintenance court and ask the court to change the order, to increase it, or to include what you have mentioned in your comment. I hope that assists you. Our last question, parental alienation by mother, psychologist and social worker process stalled, court process going in circles, please advise. You know, these are challenging questions to answer because I got a theoretical answer, but it doesn't mean the theoretical answer will necessarily work. My answer generally on these type of matters is you need to just push the process. Your lawyers need to do that, you need to do that, so that the matter can become to finality. I do not know why the psychologist and social worker process stalled. Court process going in circles. It seems to me that everything is just going badly. Someone needs to come on board here, unpack this entire case, find out where the problems are, because remember the social workers, they're looking at the matter from their point of view. They use this a file, so they're not invested in the specific matter. They close your file, open another file, the invoice, and life goes on. The court, you are just a file as well. Unfortunately, and tomorrow there's a different magistrate, different officer, and a psychologist and a social worker. So they do exactly the same. You're the one in the middle here, where everybody around you is going circles around you and the other party as well. You need to stop it from happening and process this application and make it, own the case and make it go towards a direction which is beneficial to you and can make it come to some type of finality. It's difficult for me to answer those type of questions, but I think that's we are going towards and what is workable under these circumstances. Before the next question comes in, I got a last comment says, thank you, you are welcome. Thank you very much everyone for partaking in this webinar. I will be online again tomorrow morning. I cannot say specifically what time because I have to be in court. I have other consultations. I will be on tomorrow morning. Please feel free to pose your questions tomorrow. Type it out so long. And once I do come online, just just paste it onto the comments on the Advocate Mohammed Abduroaf Facebook page. Thank you for your time. Thank you for all the questions. I hope I answered it, and I'll see you next time. Have a lovely day.